Okay, please be seated. Welcome back to the Supreme Court of Maryland. We have our second case of now the afternoon, case number 20 of the 2022 term, Baltimore Police Department versus Open Justice Baltimore. For those who weren't in the courtroom beforehand, I'll note that Justice Watts is appearing on the polycom, so you can see her just to Justice Gould's right. And if you hear a question and don't know where it's coming from because of the way the sound system works, I would urge you to look toward that monitor. And with that, I will turn to Mr. Redmond. Please begin.
Thank you, Your Honor. May it please the Court, I am Michael Redmond, here today with my colleague Matthew Bradford on behalf of the Petitioner's Baltimore Police Department, or BPD, and the Police Commissioner, Michael Harrison. The Maryland Public Information Act, or MPIA, specifically the General Provisions Article, Section 4206, allows record custodians to recover the actual cost of producing documents requested under the Act by charging a reasonable fee. It also allows, but does not require, record custodians to waive that fee if the record custodian determines that the waiver would be in the public interest. The language of subsection E of 4206 is very specific. It requires determination that the waiver would be in the public interest, not just that production of the requested documents would be in the public interest, but that it would be in the public interest for the taxpayers to foot the bill for said record production. A determination of this kind, whether public funds should be spent on a particular project, necessarily involves a certain degree of cost-benefit analysis. I'm sure we all agree that transparency, oversight, and accountability in policing are all vital public goods. And any project that intends to increase those things is meant to further the public interest. But that is not enough to allow a fee waiver under 4206E. If it looks like a particular record request is likely to provide only a very small amount of these public goods at a cost of a very, very large expense, it is not in the public interest for taxpayers to pay that production for that production of that record request.
Do we need to agree with you in order to rule for your side that it's not in the public interest, or just that a reasonable person in the chair of the custodian could conclude that?
Yes, you do not need to agree with me at all. That is, the standard of interest is an arbitrary and capricious standard of review. My apologies. Yes, it simply is a very extraordinarily discretionary standard of review. It's really just whether there was a reasonable, rational basis for the agency's determination. Does that answer your question?
It does.
Okay. And so if the agency does not determine that the waiver would be in the public interest, then a fee waiver is not permitted by the statute at all. And the language of the subsection E of 4206 is also very specific about who must do this weighing of the costs against the benefits. The waivers are only allowed when, quote, the official custodian determines that the waiver would be in the public interest. And thus the General Assembly made it clear that the record custodian, the administrative agency answering the request, is the entity that performs the discretionary determination as to whether the waiver would be in the public interest.
Mr. Redmond,
yes.
Just kind of take it further than Chief Justice Sager's question just now. I know that this court hasn't ever addressed the language in the statute, but the Court of Special Appeals has in 3 reported opinions. And my reading of those cases, it appears that the Court of Special Appeals tied maybe the relevant factor analysis to the standard articulated in FOIA, which whether the requester is seeking information for the benefit of a public purpose rather than commercial, and whether the disclosure of the records would shed light on public controversy. And that analysis, I'm wondering if, based on what you just outlined, is there could be other factors such as the cost of production. Do you believe that, starting with the Burke line of cases, they've identified the universe of potential relevant factors that a custodian might consider. And I guess I'm talking about cost and maybe the size of the department or the organization. Can the custodian take into account more than what was articulated, say, in Burke, in determining whether to exercise that discretion?
Yes, Your Honor. The custodian should take into account whatever relevant factors appear to be before them on a case-by-case basis. If obviously each agency is going to be different, even police department to police department, they're going to have different sizes, different situations, whether you're under a consent decree or not, situations like that, how much information is already being made to the public. All these different factors, if they're relevant, they should be considered. And even when the requester brings forward and gives additional information to the agency, they should consider that as well. So I don't think there is a set universe of the factors that must be considered and only considered. Certainly there have been things that certain guidelines set up by the intermediate court's decisions, such as in Burke, you can't only consider the cost. And in action committee, you cannot consider unconstitutional factors like viewpoint discrimination. But that doesn't define the entire universe. And certainly the FOIA precedents provide persuasive authority for suggestions of other things that could be done. But it's important also to note the differences between the FOIA statute and the Maryland Public Information Act, specifically because in FOIA,
Keep going. The monitor there changed off, but we're just all making sure that Justice Watts was still with us, and she is. So,
but the FOIA specifically makes the waiver mandatory when public interest, when the disclosure is in the public interest, according to the definition in FOIA, and it also specifically creates a de novo review of that question. Whereas in the MPIA, there is no such thing. It specifically makes it discretionary by saying that the agency may waive it, and also does not define what in the public interest is, but rather makes it a discretionary determination by the agency, the record custodian.
Does the custodian also have the discretion to determine what the relevant factors are?
Well, I think that has to be really a kind of a first step of an analysis is really what are we going to consider? We're considering these things. That is part of the discretionary process. Does that answer your question?
Well, would it be appropriate for this court to enumerate the potential universe of factors and send it back to the custodian to reconsider?
I think that it would be difficult from a logistical point of view to try to enumerate all practical, all possible relevant things, factors, just because every single one has to, every determination has to be made on a case-by-case basis. Certainly, this court can provide guidance as to what some things that are off limits, perhaps, or some things that generally will be in a cases like this. But there still needs to be the flexibility that was written into the statute as to the case-by-case in some situations. Even if there is a guideline put forward by the court that this is usually important, that in other cases the agency will have to say, yes, well, although that is usually important in this particular case, this outweighs, or this is why that isn't here.
So in the summary judgment record, let's say the summary judgment record reveals that the custodian considered factors A, B, and C. Mm-hmm. And we review it and we say, well, A, B, and C are relevant, but factors X, Y, and Z are also relevant, and we're not satisfied that those factors were considered. Is that a basis for us to send it back for reconsideration, or should we say that It's the custodian's discretion to decide that it's A, B, and C and not consider X, Y, and Z.
So now we're moving basically one layer back as to the discretionary decisions, and they're all discretionary decisions here, the discretionary decisions on what factors to include. If you look at the record and say it was reasonable for them just to decide to consider A, B, and C, if they had a rational basis for excluding D, E, and F, then that needs to be affirmed. If you see it, how could anyone possibly look at the record here and ignore D, E, and F, and that is absolutely irrational, then that would be a reason to overturn it and say. And this then goes to the remedy, to the third question presented. Then it would be appropriate, unless if you thought it was done in bad faith, that if someone was secretly, or if there was evidence that it was being done in bad faith, that it was purely a rubber stamp kind of thing, then you could simply reverse it. But where there isn't any evidence of bad faith, when there isn't any evidence of prejudice, the proper remedy would be, in keeping with this court's precedents in Foy, to remand to the agency to consider D, E, and F as well.
Talk about bad faith. One of the themes, if you will, of the respondent's brief is that sometimes these cost estimates and rejections of this can be used basically as a feint to deny the records at all. Is that what you're talking about? As in other words, if the denial of the waiver were not because there was a real determination that the waiver wasn't in the public interest, but denied with the hope that would prevent the disclosure of the documents at all, is that evidence of bad?
Yes,
bad faith?
if there were actual evidence of that in a particular case, that would be a reason to flat out reverse. That does, perhaps in Burke, it kind of suggests a little bit of that, because the custodian, instead of letting the reporter look at all the documents, the custodian simply said, there's 160,000 pages, 25 cents a page, give us $40,000 and we'll let you in. Although bad faith wasn't mentioned in the opinion, it seemed to be suggested, which is why even there, they didn't say, okay, you've got to produce all 160,000. The court said, you have to let the reporter in, look, and up to $500, you have to waive that. But if it gets more than that, then you can object, see if you think it's not in the public interest. Does that answer your question?
It certainly addresses it, yeah.
Okay.
I have a question, Mr. Redmond.
Yes.
Mr. Redmond, since the custodian is required to consider any relevant factor that may be in the public interest for disclosure, would you agree, or do you think that a relevant factor in this case was that disclosure of the information would have shed light on issues pertaining to police misconduct in Baltimore City and very public controversies involving the police department?
I believe that a relevant factor that was considered was whether and if this production could shed new and additional light onto the public controversies about police misconduct and use of force investigations. I think that certainly was relevant, and I think that the police department did. If you look at Chief of Staff Eric Melison's affidavit on page 145 to 147 of the record extract, one of the first things that he talks about is the city's partnership with the Department of Justice and the work that it's done and all the information about how the city deals with the police misconduct investigations and talking about the consent decree monitoring team, referencing their website, all the information that is there, talking about that field of information that is already publicly available, it was part of the consideration of saying, well, will these documents, now that they're in the form that they were going to be produced in 2020 before Anton's Law was passed, with massive reductions, it still need to have a great deal of redactions, but even then there were even greater redactions were necessary, such that a lot of them wouldn't even have the officers identifying information, because at that point they were still personnel files. They decided that looked at that and said, will this add a great deal of more new information, especially because these are not records that are straightforward narrative readings that can be comprehended very easily unless you're familiar with police, disciplinary, or investigation files. They can be quite confusing. And so
I'm going to try to narrow my question a little based on your answer. It appeared that the department did consider the information that you're talking about, but concluded that the interest was in the public gaining knowledge about the department's operations and activities, and that disclosure wouldn't shed light on the department's operations and activities, as opposed to the public's interest in transparency and simply gaining knowledge about the facts involved in the materials sought.
Well, the operations and activities that I believe that the Chief of Staff was discussing was the operations and activities of police misconduct investigations and use of force investigations. So, the magic words there were perhaps not said in the way that the intermediate court subsequently stated them, but the content, I believe, was the same. The content is there. And certainly it's not that the redundancy analysis that was done wasn't trying to say that all the information that this could possibly ever give to the public is already there. That's not the case, but rather it was saying that the general goals that the public goods that that this appears to be trying to put forward, to trying to advance, those are still being advanced, are already being advanced. Is how much more good this is going to do, we can't tell, largely because we didn't know exactly what they said they were going to do or how they were going to make this available to the public and understandable to the public. Does that answer your question, Your Honor?
Not really, but I do understand the point that you're making.
Okay.
If I understand the point you're making, an economist will say that the marginal utility of the additional information would not be worth the marginal cost.
Exactly, Your Honor.
And that there's an overlap in these operations and activities just in the public interest of having the information. But don't you think that there really is a separately identifiable factor in the public information separate from how the department is handling or responding, but the public knowing the content of the allegations, the content of the records?
Well, the content of the records would really only, I think, provide a significant amount of benefit to the public if they're put forward in a way that can be readily understood by the public. And now, if a journalist taking the information, synthesizing it, talking to experts, that kind of thing, and then explaining what these complicated, highly redacted documents are showing, that is a much better is much better candidate for providing viable public goods. Whereas simply when we looked at this in 2020 and said, okay, these are some complicated, specialized documents that are going to have a lot of information redacted, including some of the most pertinent information, like the names of the officers, redacted. That just simply being Well, we didn't know what was going to be done with it. That's part of the problem. So as best we could tell, we could only assign a very limited amount of possible, public utility to that to weigh on the scale against a truly massive cost of hundreds of thousands of dollars. Does that answer your question?
I do understand what you're saying.
Okay.
Could I ask you, the police department had also suggested that it prepare summaries of the information. How exactly does that work? Are the summaries prepared and the requester then has an opportunity to still to inspect the documents and to see whether there is validity to the summary and whether it would be helpful for whatever its purposes are in requesting the information?
Well, the requester doesn't have the opportunity to then inspect the unredacted full documents. In many cases, in this case, for example, the court had the opportunity to review in camera a sample of unredacted documents. But generally, the way the summaries work is that there are often it is taken. For instance, in the case of internal affairs investigation, the IA Pro spreadsheet summary is something that's generated during the investigation, and that can be supplemented with small narrative summaries about things. And that, because it doesn't have the original documents with all the officers and witnesses' names and information and stuff like that, it is much easier and takes a much shorter time and lesser expense to redact that to provide to the requester. And often then the requester can then look at that and decide, do I actually want to go back and make a new request for the full documents because, yes, it looks like there are documents that will actually be useful to me, rather than doing them all at first.
So that is the end of the time that you would reserve. You can keep talking, but at this point you would be eating through rebuttal.
No, thank you. I will reserve my remaining time for rebuttal. Thank you.
Okay, thank you. You'll have the 10 minutes you reserved for rebuttal, and now we'll hear from Mr. Zernheld.
May it please the court. Matt Zernhelt on behalf of Open Justice Baltimore, OJB. This is a Public Information Act case, and the Public Information Act spans a great mass of public documents, from a business wanting to request contracts for a bid that they did not make, so they can see what they can do better next time and get commercial gain, venturing into records that are actually of public interest, but maybe for an individual, like a defendant or an inmate that wants to review their record and review their case. And then really on the far end of the spectrum, where we are in this case, police misconduct records. And the requesters in this case, the public, were very, very intentional in what they requested in this case. They didn't just request police misconduct records, they requested the most aggressive police misconduct records. They requested the most aggressive uses of force of the police on members of the community. And when I say uses of force, and significant uses of force, I mean in custody deaths, use of a firearm, hitting someone with a police car, sending someone to the hospital. And these are the records, and more significantly, the follow-up investigations. How did the police look into if this was a justified incident? Did this get shortchanged, or was this investigation conducted with integrity? These are the investigations that BPD said it's not in the public interest to show, to turn over.
So why do you say? Why do you say, and this is something that in your briefing, there seems to be a conflation of in the public interest to disclose and in the public interest to waive fees. And there are, and so what you just said is something that I don't see anywhere in the record where they said it's not in the public interest to disclose, nor have they defended it on that basis, at least in this court. So I want to try to find out why it is that you treat those two things as identical when the statute talks about public interest to waive fees?
Sure. When you impose an enormous fee on a record, you're effectively denying that record, because no community member can pay these fees to access these records, so it's a de facto policy of denial.
Well, what's the record evidence as to the financial ability of your organization to pay? Because there's letters that says we're prepared to pay the reasonable costs.
We said we would be prepared to pay reasonable costs, and I think this is also a good. I'm glad you asked. OJB requested a fee waiver 10 times. We requested. We tried to engage in an iterative process again and again and again, and we got silence. And they just came back and didn't even respond. They just imposed an enormous fee. So they're almost asking us, look into a crystal ball and tell us, what you want us to hear, and then faulting us for not knowing their, three-part analysis that they, only showed us upon in the Court of Special, or the Appellate Court of Maryland.
Well, to be clear, they could have done a much better job, for sure, in responding to your records request. But once the affidavit evidence is presented to the circuit court, is it a determination of whether the custodian acted arbitrary and capriciously, or is it, well, you didn't respond 10 times, therefore they must pay? And I guess a follow-up is, I don't see that you objected on the basis of reasonableness.
We didn't object on the basis of reasonableness because at that point we didn't feel that fees should be paid at all. So this, to us, the issue in this case was whether fees should be waived, period.
Well, what if Bill Gates were financially supporting your organization?
That's a great question. I think, unfortunately, we don't.
Would a fee waiver, in your view, still be required?
Your Honor, unfortunately, I don't think we have to answer that today because Bill Gates is not. But I hear you.
But you're making the point that the fee was generated to impose a barrier of your organization to obtain these documents.
I don't want to.
And so that raises the question of, well, what evidence is there in the record as to the financial the financial ability, the resources available for your organization to pay that? Because you've made a pretty bold statement.
Sure. I'm not imposing intention because I don't think that's a burden on us.
I'm not.
Right.
But then you're saying that it is in fact a barrier. Forget intent.
Right. The de facto policy that's been instilled is we have these enormous records, and by their inherent how we impose them, you can't get them.
But if Bill Gates were backing your organization.
Well, what we told them, I think it was our 10th letter, we told them that we are, and we said this numerous times by them, but then finally, and this was before that affidavit, we are again we are under nonprofit status. All of our funds go back into the community. We have no excess funds, and we are asking for a fee waiver. So we did tell them that, and they knew that we were under fiscal sponsorship. And the sole purpose of fiscal sponsorship is to help organizations that are incubating. It's an incubator because an organization cannot self-support themselves. We will pay you a little bit to help us with our administrative burdens because we can't pay for our administrative burdens.
So I think you started by correctly noting that the Public Information Act applies to local governments. It even can apply to nonprofit organizations if there's a nexus to a local government. And maybe some of those nonprofits might not have the financial wherewithal of Baltimore City. Would you agree that under the rather broad and relevant factor language that the General Assembly has used, that fees could be, the cost of production could be a relevant factor in some instances where the organization that is, the custodian is required to produce documents, maybe doesn't have the same taxpayer budget that Baltimore City has?
I think in this case, Burke had said the case of Burke said it was not to be considered.
Not to be considered at all? Maybe not the determinative factor, but certainly a custodian could consider that, couldn't they?
Yeah, they can consider it, but they can also are to consider our ability to pay, and I believe we did make it clear that we can't pay such enormous fees, and the sheer nature of these records. And it becomes ironic at a point that the larger an officer's misconduct record, because they have so many complaints against them, the more expensive it is for the community to review that officer.
Which is a good point, and you make a lot of good policy arguments as far as why you think the government entity should bear this burden, and the BPD specifically. But one of the things as I look at the statute and trying to understand what our role is in interpreting the legislative intent here is a statute that says the custodian may waive if it determines that the waiver is in the public interest, which seems to be a legislative judgment that the entity that is making the call here is the custodian based on factors about whether the waiver is relevant. So how does this court get to, in light of that statutory language, do what it seems like you want to do, which is make sort of an independent determination if disclosure is in the public interest, and then rule on that basis?
Thank you, Your Honor. I think, broadly, the General Assembly did insert this fee waiver provision for records that are innately in the public interest. And when we talk about records that are covered by the Public Information Act, if this is not on the far end of the spectrum, then I can't imagine what that provision was inserted for. And I think when we look closer, it's not as discretionary as my friend Mr. Redmond argues it to be. I see it a little differently. What I see it saying is a fee waiver may be granted, but what is required of the agency is an actual consideration to be made. So they are tasked with reviewing relevant factors. And that's not a grab bag, pick out some factors, but the relevant factors. And what relevant factors exist here. And I think this is another factor, if we could in a second talk about de novo review and why de novo review is actually fitting in the statutory scheme, but also here, this is not an agency-specific statute, so specific factors aren't relevant across the board, but we need to look at relevant factors for this specific request. And in this specific request, again, we're asking for police misconduct records. And police records under the PIA first have been carved out to specifically be made available. The General Assembly could not have been more clear that they want police misconduct records to be disclosed.
At the same time, they didn't carve out that the Public Information Act applies to all agencies covered by the Public Information Act. And the legislature hasn't carved out a separate fee waiver for police activity, and in fact, that's what's being studied by the task force. So how do we say, is it this court's job to say that the plain language of the fee waiver provision is different in cases of police misconduct? And maybe it should be, but shouldn't that be determined by the legislature and the task force with all the stakeholders at the table that's being undertaken right now?
I'm glad you bring up the task force. I think the task force in that legislation was a little bit of a misnomer. The journey of that task force, originally the proposition of let's make this, the bill that we want to make it extremely clear that misconduct records are to be provided at no cost, up to 500 pages. The folks on the ground asked the legislator that we do not move forward because that's not actually what we want. There hadn't been communication there. That's why that bill was withdrawn. There was a second bill that was then put forward that that took the 500 pages out, and that the records would be completely made available at no cost. And then it went to task force because most legislation is on a 3-year timeline. And that was only called for because after Anton's Law, we saw such a backlash of police departments refusing to comply in one way or the other and doing things like accepting the public interest, but in granting a fee waiver request to claim compliance, but then only giving a fee waiver in a very minuscule amount to then leave such enormous fees that access to the record is still effectively denied.
And I think, does that get to the point of bad faith that I talked a little bit about with Mr. Redmond, where if there's an indication that the denial was based not on an indication that the fee waiver wasn't in the public interest, but on a desire to avoid the disclosure, that would be bad faith sufficient, I think he said, to just reverse, not to even send it back for a new determination. And is that the and maybe not responding 10 times and is can be construed as that type of evidence, but isn't that where that belongs rather than sort of rewriting the words of the statute should make it non-discretionary?
I don't know if we have to go all the way to bad faith. I don't know if that's the question that we have to answer today. I think the question is, did they genuinely consider the relevant factors? So they just might have done a poor job and not considered and done their job. This was a substantive error. And I think we also disagree there. This wasn't a procedural error. It was a substantive error. They didn't consider the relevant factors.
So what do you believe the words relevant factors mean? Is it a discrete universe of criteria, or is it criteria that the custodian can apply in his or her discretion, provided that it's not in bad faith and for a constitutional infirm reason? What does relevant factors mean?
I think in this case, we're talking about the police. They're a special class of government employee, government agency. They're given the task with extreme service, but also burdened with lethal force, the ability to deny and deprive civil liberties. They can take an affidavit to a judge and get authorization based on their word to invade Fourth Amendment rights. But even the judge doesn't have any Brady repository to know anything about this officer, because police departments are not making the backgrounds or misconduct history of these officers known. So I think the relevant factors of what agency we're talking about is specific. And here we're talking about police. In this specific incident, we're also talking about the Baltimore Police Department, which I think also needs to become come into play. And this is a context-specific review. So where the statute says review of the relevant factors, again, my reading is not that it's a grab bag and you can pick and choose, but what would a reasonable person think are the relevant factors here? And I think, again, I want to bring this back to de novo review in a minute.
So what factors that are relevant are you contending the petitioner did not consider?
I agree with the court below that what was not adequately considered was the relevant controversy that has happened in Baltimore. Not just Baltimore, but across the country.
What's the evidence in the summary judgment record that was not considered?
That there was no evidence.
There's an affidavit.
But the affidavit doesn't adequately address the relevant controversy that has gone on in Baltimore. I mean, in Baltimore, we're not far removed from the...
It references the Justice Department oversight, doesn't it?
I think the consent decree is a major distraction in this case, and I'd like to address why. I think in 2015, with the death of Freddie Gray in police custody, the community did not feel heard, and they took to the streets. They marched. There was police reaction. There was an extremely divisive time in Baltimore that is still felt which brought the DOJ in, and that instigated the consent decree. The BPD didn't fight it out; they willingly entered, but they saw the writing on the wall.
But the consent decree, doesn't the monitor have to file semi-annual reports?
They do, but
so that's an ongoing mechanism of disclosure and information. And isn't it fair for the BPD to weigh the costs of the information you're requesting against whatever marginal benefit would be achieved when compared with the information provided in these semi-annual reports? Isn't that a balancing test that's fair for them to consider?
if we do consider it, I think we need to consider it fully.
But they said they did. That's the thing.
But I think a rational person needs to consider that, because BPD was under investigation under the consent decree for 2 years when the gun trace task force was freely operating. It's not BPD that policed themselves and uncovered the gun trace task force. It's not even the consent decree or the DOJ that unveiled the gun trace task force. It was a string of deaths that flagged a separate federal investigation that brought federal investigators in to find the gun trace task force. And I think that's not just instigatory or inflammatory, but very relevant, because when this first request was made was in 2019, when those trials were still going on and very prevalent, and the feelings were very vibrant in Baltimore when we asked, hey, when this happens, how are you responding? Can you show us? And I don't think there's anything redundant if you're just going to show us, aggregate data. That's not showing us how in-depth you're going in an investigation.
You make very compelling arguments as to, the importance of transparency and the importance of additional information, but the question is the discretionary decision that's vested in the custodian and the custodian's balancing of those. Is there anything in the summary judgment record that could tell us that the custodian didn't, in fact, engage in balancing, even if we disagree with the outcome of that balancing test?
Well, I do want to stay on the record, because if we could, before we lose that thought, what's argued in the brief, I think BPD introduced a little bit of confusion in that, particularly in the things like ability to pay, that is not part of the memorandum, like where BPD argues OJB made a $20,000 payment. That wasn't taken into consideration because that was made after the affidavit was signed, which both were made after the denial, and that was advanced on OJB's behalf. That wasn't made by OJB. That was a payment made as a litigation expense because we wanted to see cert records so we could show that these are actually in the public interest. And I think I don't want to step too far out of the record, but after 15 months, we did eventually get those records, and I would very strongly disagree with the characterization that these records are heavily redacted. So I don't agree that there was genuine consideration made when the affidavit says, or the records
to what?
That these records would be not understandable. So where the record says that these records would not be understandable to the general public, we found them to be extremely understandable and easy to follow, because the redactions are simply, anything that's a medical record inside. Okay, we don't need to see that to see how an officer is investigated, or a witness. Okay, that's a witness's name. We don't need to know what the name was, or relevant criminal information. That's fine. But also, I think that argument is basically extremely contradictory to what the PIA is. It's arguing that we're too plebeian to understand what the government's doing here, and it undermines the purpose of the PIA. which is set upon this idea that it's a well-informed public, which fuels a functioning democracy.
One thing that I'd like you to address is the burden when seeking a waiver of the organization that is seeking the waiver. There have been a whole lot that's come out in the briefing about the purpose for requesting these and the purpose that they might serve, and you've spoken persuasively about that. But there was a whole lot less in the material that went to the BPD at the time. What do you think, and keeping in mind that this is a discretionary determination for the custodian, what do you think is the burden, if any, of the requester to show as far as why they think it's in the public interest to have these disclosed and to have the waiver given?
Based on precedent, there is none. If we're looking at action committee, the requester in that case didn't submit anything based on the facts in that case. So I think we've met that burden. But I think we've gone well and above, and we've also had an established relationship with BPD, which we talk about in the record. So there was ongoing communication, and we did our part to, and beyond what we showed, we reached out, and they put up a wall, so they essentially buried their head in the sand to make this decision. And when we talk about review of the decision, we do feel that de novo review is appropriate, and we would ask that this court correct the Court of Special Appeals holding on that, and that first the arbitrary and capricious standard had simply been inserted with no reasoning as to why.
Before you get there, I'm not sure, and I do have a question about that, but to follow up on Chief Justice Fader's question, I think he was asking about what's required of the requestor, and under the statute, the custodian has to consider the ability to pay, is it enough, and other factors. So it's not just based on ability to pay, but is it enough to just say we're a nonprofit corporation and we don't retain profits? Is there more that the requestor has to do to show ability to pay?
Counsel for the agency signed on behalf of the agency and said we do not have the funds to make this, and we request all of our funding goes back in the community. And we're a nonprofit. We're a public interest organization trying to use this for public interest purposes. I don't think, especially within the statutory scheme of the PIA, the requester should be faulted for not knowing any more requirements beyond that.
Well, then on the de novo review, are there any cases where this court has ever conducted a de novo review where a matter is within an agency's discretion?
I think this is different being a PIA case because the PIA usurps the Administrative Procedure Act, and that's what would set this.
The Administrative Procedure Act would never apply here because we're talking about a local government. So putting aside the APA, I guess in even local government context, are there any cases where this court has applied a de novo review where there's statutory authority for the agency to exercise its discretion?
Not that I'm aware of, but I think even if not, this case would stand aside because of the language of the PIA and the statutory scheme of the PIA, which is founded in openness of government. The statute that we're looking towards, or looking to, which enables a requester to file in the circuit court, where the PIA wants arbitrary and capricious to be applied, It specifically says so, and that's where damages against the agency are to be used.
So are you asking us to conduct a de novo review, conduct the balancing test that the custodian is required to do? You want us to do that de novo? And
Yes.
substitute our judgment for you think that's the court's function?
Yes, I think the court should conduct a de novo review of whether genuine consideration was made, whether they did their job of reviewing the relevant factors.
The Court of Special Appeals used the arbitrary and capricious standard. You've responded in your brief that this should be a de novo standard. You haven't filed a conditional or a cross petition raising this de novo issue for the court about the standard. This is not an issue of even statutory interpretation. And we're reviewing the Court of Special Appeals' decision. We're here on the issues that were raised by the petitioner. So I don't really think I'm going to follow up with a question about the de novo standard after making those remarks. I'm going to move on to another question. The statute that we're looking at provides that after consideration of the ability of the applicant to pay and other relevant factors. So your ability to pay the fee is one specific factor that's set out in the statute. I see in the record that you indicated in a letter, it's at E338, that no excess funds exist. Yet in another instance, you indicated that you were willing to pay, I think it was reasonable fees. So my first question is, can you justify those two pieces of factual information that you've supplied?
Your Honor, we initially said we would be able to pay reasonable fees. We shortly thereafter, but at the same time, we asked, could a fee waiver be granted? In our mind, what we thought of reasonable fees, we didn't expect to get such enormous fees as what came down the line.
Did you ever provide any indication of what you thought would be reasonable fees?
I'm sorry?
Did you ever provide any indication or suggestion of what you thought would be reasonable fees?
I don't think there was anything in mind.
All right. I'm going to move on and ask about the other relevant factors. The statute does not specifically indicate that the cost to the agency is a relevant factor or an independent factor you consider. Do you have a position for the court as to whether or not the cost to the agency can be a relevant factor?
I think it can be a relevant factor, but only one of many. And I think I agree with the court below that what is kind of the elephant in the room in this case was the controversies that the police department have really gone through over the past decade in Baltimore that have put such a divide between the police department and the community, and that have really alienated the community and the police department. And this denial of not letting them in, particularly under a statute that's supposed to be transparent, further alienates them. I think it's that denying that review of that relationship is what shows that this wasn't genuine consideration. I see my
okay,
time.
So the reason, is there a time issue?
He is out of time, but you can, of course, continue to ask questions, and he can stay to answer the questions.
I'm just going to ask one final question about the reasons given. In one of your letters to the department, you indicated that the public interest factors for transparency and accountability. The decision by the department said that your reasons were vague, that you didn't really supply enough information. Do you want to make, in closing, any remarks to the court about whether or not you supplied enough information about the public interest factor?
Yes, Your Honor. We opened ourselves to communication as best we could. We were open to, any phone call, any email to expand upon what we would have done. OJB has nearly a singular purpose. We have a website that gets averages 10,000 hits per month to make BPD transparent. But BPD did not work with us whatsoever. We got a stonewall no. And I think that shows, that the genuine consideration was not given. And I think this imposition of fees really establishes a public policy that undermines the intentional public policy of not just the Public Information Act broadly, but Anton's Law specifically.
I think I'm following the nature of your response to the question. Thank you for those remarks.
Thank you, Your Honor. Thank you to the court.
So I don't see any other questions, so thank you, Mr. Zernhelt. Mr. Redmond, you do have the 10 minutes you would reserve for rebuttal.
Thank you, Your Honor. May it please the court. There is not a special MPIA for police departments. There is not a special MPIA for the Baltimore Police Department. Next legislative session, there may be, but as it is right now, the same MPIA applies to the Baltimore Police Department as it does to every other state and local agency.
That is true, but relevant factors can differ based on the particular entity that is being asked, and you wouldn't look at the same factors as relevant to a request to the BPD as you would to an entity that has never had a record of police misconduct like the BPD has, right?
Absolutely, Your Honor. And when looking at it, the factors include not just what the record is, but all of the history, not just the bad history, but also what has been done and is being done to try to address those exact things. But really, I was going towards more that the standard is the same. It is the same arbitrary and capricious standard. It is the same standard that it is a agency determination. These are the things that need to be applied equally across. And the de novo argument is both wrong and waived and not petitioned. I think Your Honors were pointing out exactly all the issues with that argument. And just as a quick factual matter on my brother counsel here has I think misrepresented that, but just to make it clear, the consent decree and the gun trace task force indictments, I believe both were entered in the first half of 2017. So there was not a significant period where one was going on without the other. And to address a few of the factual things that have been brought up as potential evidence of bad faith, claiming that there were 10 requests for a fee waiver before getting the response. Those 10 requests were made before a fee was established. A reasonable fee there was nothing to waive, nothing to give an answer about until we tried to go through the iterative process of, okay, this is what you've requested. We take the time to try to figure out what all the information, what all responsive documents there are. Was there a response that said, we're trying to come up with an amount and we'll get back to you when we do? There are lots of responses. Most of that record extract is responses and back and forth between our trial counsel and the requester. I think there's 12 different requests, all voluminous from this particular entity, and each year we have thousands of these requests. The requesters, each individual requester for each individual request may not feel like they're getting as much attention as they should, but that is not an evidence of bad faith. It is an evidence of an absolutely overwhelming amount of work that is trying to be done by a finite group of people with a finite group of amount of resources. But here, that once We tried to limit, tried to make it see if they could work with summaries for first thing, or otherwise narrow and make it such as a less expensive, less burdensome, and easier to produce more quickly response. They said, no, we want absolutely everything. So we said, okay, this is our best estimate as to what it's going to cost. Give us any information, any factors you think we should consider about this. And then we took what they gave us and considered it. And Open Justice apparently thinks that it was our responsibility to go out and say, oh, well, really, what do you really mean by this? Go and actively gather, look at their webpage, try to figure out information that they didn't actively give to the agency. And that's simply unrealistic for the amount of volume of requests that are presented to an agency, and it's not required by the statute. So I think the consideration that was done reasonably. It was not arbitrary and capricious. It identified the information and factors that were before it that the chief of staff thought were relevant, and it laid that out. Once this was in court, it laid that out in an affidavit saying, the chief of staff laid that out in an affidavit explaining these factors and explaining how he considered them. And although it might not be a model of clarity, then the trial counsel and myself have tried to explain his explanation a little bit better. But I think that any fair reading of it shows that it was a reasonable, rational consideration, that this determination was not done arbitrarily or capriciously. It might not have been the same determination that anyone in this room would have made, but that's not the standard. The standard is, was it rational? Was it reasonable? And I believe it was, and I ask this court to affirm that agency determination, and if not, to remand for consideration of whatever additional factors this court believes are necessary. Unless your honors have any other additional questions?
I see no questions. Thank you both for your arguments. The court will stand adjourned until February 2nd at 10 a.m.
All rise.